Hello future judges. Today we are going to study the Indian Partnership Act 1932. Indian Partnership Act 1932 came from Chapter 11 of Indian Contract Act 1872. In the year 1932, on 8th of April, the legislature decided to pass a new act and to repeal the Chapter 11 of Indian Contract Act. So out of that Chapter 11, we got the Indian Partnership Act 1932. The Indian Partnership Act came into force on 1st October 1932, except Section 69. Section 69 of the Act, which talks about the effect of non-registration of partnership firms, it came into force on 1st October 1933. So, let us begin the Indian Partnership Act by understanding the purpose and object of Indian Partnership Act. The preamble to the Act says that it is an act to define and amend the law relating to partnership. Indian Partnership Act का object और purpose यहाँ पर simply ये दिया है कि ये define और amend करने के लिए है जो partnership के laws हैं उन्हें. But there is a deeper purpose and meaning to this one sentence. Indian Partnership Act governs partnerships in India. It governs partnerships in India in the sense that it governs the relations of partners It tells us how to create or form partnerships. It tells us how to dissolve partnerships. It tells the rights and duties of partnership. Rights and duties of partnership firms and the rights and duties which are mutually established between partners are also governed by the Indian Partnership Act. Between partners as well as with third parties. And along with all of this, the Indian Partnership Act also talks about registration of partnership firms. Registration of partnership firms. So, this law is not exhaustive, but it deals with a lot of issues relating to partnerships in India. Why I say that this law is not exhaustive when we come to partnerships? Because now we also have the Limited Liability Partnership Act of 2008. So the Limited Liability Partnership Act also governs the provisions relating to partnership. Although it is only relating to limited liability partnerships, but still we cannot say that Partnership Act 1932 is an exhaustive law on the point of partnerships in India. So let us move on and understand the basics of Indian Partnership Act. Section 3 of the Indian Partnership Act states that the application of the provisions of Indian Contract Act which are not inconsistent with the express provisions of this act shall continue to apply to firms, which means that the provisions of the Indian Contract Act which are applicable on firms and which are not inconsistent or which are not violative of the Indian Partnership Act will continue to apply to the firms. Let us understand this with an example. So, let us say that A and B enter into a partnership to do a business. Now, this whole creation of partnership between them, the relationship with the third parties, this will be governed by the Indian Partnership Act 1932. But from this point onwards, when their firm, now this is a firm of A and B. Now, when this firm will enter into a contract, let's say with another firm or individual, then the provisions of Indian Contract Act will continue to apply on the firm of A and B. Here, their interpersonal relationship, their rights and liabilities of the partnership and their duties towards the third parties, etc., will be governed on the basis of the Indian Partnership Act of 1932. But when this firm enters into contracts with firm number 2 or other individuals, then the provisions of Indian contract are still very much applicable, depending that they are not inconsistent with the provisions of Indian Partnership Act 1932. So let's say if Indian Partnership Act 1932 states that you cannot hold a party liable, a third party liable, if you are not registered, then under Indian Contract Act the firm will not be able to do so, because the provisions of Indian Contract Act cannot override the Partnership Act. The Partnership Act cannot be overridden by the Indian Contract Act. Now, let us understand Section 4 of the Indian Partnership Act. Section 4 of the Indian Partnership Act talks about partnership. What is a partnership? Who is a partner? What is a firm? And what is a firm name? So the most number of questions are asked from this portion only. The most number of questions in prelims and mains are asked from this portion. What is partnership? Section 4 defines partnership as the relation between persons. It is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Let us break down this definition and understand the various important elements or essentials of this definition. The first thing that we see here in Section 4 of the Indian Partnership Act is the definition of partnership. And it says that partnership is a relationship between persons. It is between persons, which means there is more than one person. At least two persons are required to make a partnership. At least two persons are required to make a partnership. So these persons, are they natural persons or are they artificial persons as well? These persons could be both natural or artificial persons, which means that legal person may also enter into a partnership. A legal person may also enter into a partnership. For instance, a company may enter into a partnership with another company, or a company may enter into a partnership with an individual. So, natural persons, all the natural human beings as well as artificial or legal persons are also included in the definition of persons here. And persons means plural. So, at least two persons are needed to create a partnership. So, it's a relation between persons who agree. So, the next essential element is an agreement between these persons. And what is an agreement? We know that from the Indian Contract Act. So, it is an agreement to do what? To share profits. It is an agreement to share profits. Now, this is not an agreement to share losses. So, it is only an agreement to share profits. It could also be an agreement to share losses, but the Act is not concerned with the share of losses. It is only concerned with the share of profits between persons. So, these people agree to share the profits of what? They are agreeing to share profits of a business. This is the next important element. They are agreeing to share the profits of a business. Now, what does a business mean? A business is defined under 2B of the Partnership Act. 2B of the Partnership Act says that every trade profession or occupation is a business. Trade, profession and occupation is a business, which means that it should be a legal business. A business which is formed for lawful purposes. The object of this business cannot be illegal. The object of this business cannot be unlawful. यानी कि अगर आप किसी इलीगल एक्ट को, किसी इलीगल बिजनेस को करने के लिए पार्टनरशिप फॉर्म कर रही हैं, देन दैट इज नॉट अ वैलिड पार्टनरशिप, बिकॉज जो एक इंपॉर्टेंट इंग्रेडिएंट है बिजनेस का लीगल होना, वो उसमें नहीं है. सो इट मीन्स दैट it should be an agreement to share profits of a business. Now, is this business carried on by these partners? Yes. The next essential element is this business is carried on by all, or it may be carried on by anyone acting on the behalf of all. It may be carried on by all or any one of them acting for all. By anyone acting for all, which means that this is a case of mutual agency. Mutual agency. Let us understand mutual agency by a simple example. Let's say A, B and C are partners in a firm. A, B and C are partners in a firm. So, any one of them may be carrying the business or all of them may be carrying the business. Let's say if A, B and C all are carrying the business of the firm, they are all partners, and if only and only A is carrying on the business of the firm on the behalf of B and C as well, then they have a relationship of agent and principal. Agent and principal. Which means that A will be an agent for C, A will be an agent for B, and if C is carrying on the business for all of them, then C will be an agent of A and C will also be an agent of B, which means that any one of them will be an agent for the other two. That means that they have a mutual agency. When the partners share the relationship of principal agent among themselves with each other, they are said to have the relationship of mutual agency. They are agents of each other. This is the last and the final essential ingredient, which is the business must be carried on by all or any one of them acting for all. Now, how is a partnership created? A partnership is created with all these essential elements by a partnership deed. By a partnership deed? Partnership deed is a written document. A partnership deed is a written document, which brings us to the important question that can a partnership be created in an oral manner? Yes, the partnership can be created by a deed which is written, and it may also be created in an oral manner. Here, the agreement between the partners could be expressed or implied by their conduct. The conduct of persons is such that they are conveying it to third persons that they are having a business, they are sharing the profits of the business and they are carrying on the business. Then this conduct or this implied behavior will also make them partners. This comes from an important case law. In the case of In the case of Haji Isa versus Sarubai, Haji Isa versus Sarubai, firm Haji Isa versus Sarubai, which is a very old and landmark judgment of Nagpur, 1938. Let us understand the concept of mutual agency with the help of a landmark case. Cox versus Hickman. (1860). This is a landmark English case in which the essential element of a partnership was discussed. It was discussed that if two persons are only sharing benefits, are only sharing the profits, can they said to be partners in a firm? The court held that if two persons are only sharing benefits, but there is no real relationship of partnership, then it cannot be said to be a partnership. No real relationship. In the present case, what happened was Cox and Wheatcroft, two persons, were creditors of a firm. So Cox and Wheatcroft, two persons who were creditors of a firm, they asked for their money. They asked the firm to return their monies, but the firm could not return the monies, so the firm came to an agreement with the creditors to give them a share of profits. So the firm agreed कि हम आपको आपका पैसा न रिटर्न करने की वजह से आपको profits का एक share दिया करेंगे. Now what happened was, when the firm entered into a contract with another person to receive some goods on credit, this person who was the defendant, Hickman wanted to recover his money for the goods that he had delivered. So Hickman sued the creditors as well. Hickman contended that Cox and Wheatcroft are, Cox plus Wheatcroft are what? They are the partners. But the court held that they are not partners in the firm, because although they are sharing the profits of the partnership, but there is no real relationship of partners, there is no mutual agency between them, and they are not conducting the business on behalf of the firm. So they were held to be not partners, but only and merely creditors of the firm. Similarly, in another case, Pratibha Rani versus Saroj Kumar. In Pratibha Rani versus Saroj Kumar, what happened was that Pratibha Rani gave her Stridhan to Saroj Kumar, who was a husband. Pratibha Rani, who was the wife of Saroj Kumar, she gave her Stridhan. It is a 1985 Supreme Court judgment. She gave her Stridhan to her husband, and the husband invested the Stridhan. He used the Stridhan in the business. So the husband used her Stridhan in the business and earned some profits out of that business. Now later on, Pratibha Rani contended that she is a partner in the firm. She contended that she is a partner in the firm. But the apex court held that the giving of Stridhan to the husband was only an entrustment of property. She entrusted her property to her husband, but it did not create a relationship of partnership between the two. The apex court stated that there are two important very important essentials to create a partnership. The first being that there must be a real physical act between two persons to start a business. A real or physical act to start a business. And the second important thing that was held by the apex court here was that this business must be carried on for sharing profits. It should be carried on for profits, which should be shared between partners on the basis of the share agreed between them. This business should be carried on by these persons, these partners, for sharing profits which are agreed between them. So, the apex court held that Pratibha Rani was not a partner in the business of her husband. In another interesting case, Girdhar Bhai versus Syed Muhammad Qadri. These judgments are very important from the point of view of main examinations, because from these judgments आपकी जो DJs के problem based questions हैं वो बन करके आ सकते हैं. तो in Girdhar Bhai versus Syed Muhammad Qadri, which is also a very old landmark judgment of the apex court, 1987 Supreme Court. In Girdhar Bhai versus Syed Muhammad Qadri, the apex court held that partnership is sometimes in certain cases a mixed question of fact and law. It is a mixed question of fact and law, which means that if it is asked whether the existence of a partnership between two people is a question of fact or is it a question of law, then your answer should be that Girdhar Bhai versus Syed Muhammad Qadri, Supreme Court 1987 held that it could be a mixed question of fact or law in certain cases. The Supreme Court said that the persons who have a mutual relationship between them will be compared, their relationship will be compared to the provisions, the principles that are set out in the Partnership Act. उनका relationship Partnership Act में दिए गए principles से compare and contrast किया जाएगा और वहाँ पर ये समझा जाएगा कि उनका जो relationship है वो partnership का है या नहीं. So, in these cases it becomes a mixed question of fact and law, and not only merely a question of fact. In another interesting case, firm Haji Isa. In the case of firm Haji Isa, apex court discussed upon the essential agreement firm Haji Isa versus Sarubai. Sorry, this is a judgment of Nagpur. 1938 Nagpur court's judgment. In this case, it was discussed by the court that agreement is a sine qua non. It's a sine qua non for creating a partnership, which means that no partnership can be created without an agreement between two persons. Agreement is what? It's a sine qua non for creating a partnership. And the second important thing that was held was that this agreement could be oral or it could be in writing, it could be express or implied, which means that a partnership may also be created by conduct of two persons. If they are not saying anything by words and their conduct is such that जो third persons हैं उन्हें देखने पे ये feel हो रहा है, ये महसूस हो रहा है that they are in a relationship of partnership with each other, then that will be considered a partnership because of their implied consent, implied agreement to be partners. Now, you must be thinking, if partners are persons, then what persons are included in the definition of person? Like we discussed earlier, that persons includes both natural and artificial persons. So, let us see a few cases on this point. In Rashik Lal and Company versus IT Commissioner 1998, Rashik Lal and Company versus IT Commissioner. 1998 Supreme Court. It was held that a Hindu undivided family cannot become a partner of a firm directly or indirectly, which means that a Hindu undivided family cannot be a partner in any firm. ना तो वो डायरेक्टली पार्टनर बन सकते हैं और ना ही इनडायरेक्टली पार्टनर बन सकते हैं. Hindu undivided family is only an association of individuals. Individuals की एक association है जो कर्ता के थ्रू ऑपरेट करती है. कर्ता उसका मैनेजर होता है और कर्ता ही जो है बिजनेस के ऑपरेशंस को भी कंडक्ट करता है. In most cases कर्ता can enter into partnership personally in his individual capacity, but a karta cannot enter into a partnership on the behalf of the HUF. A Hindu undivided family therefore cannot enter into a contract. It is merely an association of individuals. It does not have an artificial or legal personality attached to it. It is not a separate entity distinct from its members. It does not have a separate legal entity. And therefore, in Rashik Lal and Company, it was held that an HUF cannot be a partner. In Ganga Metal Refining Company versus Commissioner of Income Tax, it is a very old judgment of Calcutta High Court. Ganga Metal Refining Company versus Commissioner Income Tax, 1967 Calcutta High Court. In this particular case, Calcutta High Court held that a company is an incorporated entity. It is a separate legal entity, so it may enter into a partnership. A company may enter into a partnership with another company. A company may enter into a partnership with another company. However, this position slightly changed. Today, a company can enter into a partnership not only with a company but also with an individual, that is a natural person. So, a company can now enter into a partnership with another company, and a company can now enter into partnership with an individual or a natural person. So, let us understand how many persons are needed. Now that we have discussed that partnership is an association or agreement between two or more persons who are carrying on a business by one or any one of them on behalf of all to share the profits of that business. So, now we need to understand how many people are required to make a partnership. We understood that at least 2 persons are required to create a partnership. Yes, this is the minimum number of persons that we need to create a partnership. But what about the maximum number of persons that are needed to create a partnership? The maximum number of persons that are needed to create a partnership according to Indian Companies Act Yes, Indian Partnership Act does not define how many, does not give a provision as to how many persons can be partners. Maximum number की कोई limit Indian Partnership Act में नहीं दी गई है. So it brings us to Indian Companies Act 2013. So the Companies Act 2013 states in its section 464 that not more than 100 persons can form a partnership, which means not more than 100, which means that the maximum number of partners that can be in a partnership firm are 100. But this provision was further amended. This provision was further amended by the 2014 Miscellaneous Company Rules. In the 2014 Miscellaneous Rules, Rule number 10. Rule number 10 has reduced this number to 50. Now, only maximum 50 persons can be partners in a partnership firm. Earlier it was 100, now it is 50. So, the central government has the power to exceed this 50 to make it 100, but the current position is that no firm can have more than 50 persons as its partners. No firm can have more than 50 persons as its partners. Let us move on and understand the partnership section 5. Partnership Act section 5. Section 5 of the Partnership Act states that a partnership is created, it arises from contract and it is not created by status. A partnership arises from contract and it is not created by status, which means that two people have to enter into a contract, they need to have an agreement to form a partnership, but partnership cannot be created by status. Merely giving the status of a partner will not be sufficient. There need to be a contract. एक contract जो है वही essence है to form a partnership. A partnership cannot be given by status. It can only be created by a contract. And it further states that an HUF carrying a family business, a Hindu undivided family carrying a family business cannot enter into partnership. A Hindu undivided family carrying a family business cannot be partners, and a Burmese Buddhist husband and wife carrying on business. Burmese Buddhist husband and wife. These are all the exceptions to Partnership Act. So these are important from the point of view of preliminary examination. Prelims में आपसे अक्सर ये question पूछा जा सकता है that who cannot be a partner. Option A, कर्ता in an HUF. Option B, the HUF itself. Option C, Burmese Buddhist. Option D, both B and C. So B and C, that is the HUF itself cannot enter into a partnership, and the Burmese Buddhist husband and wife who are carrying on a business together cannot enter into a partnership. A Burmese Buddhist husband and wife who are carrying on a business cannot be partners. So now we understand the meaning of partnership, that partnership is a relationship between two persons. So it is a relationship or an association between two persons. The minimum number is 2, which may extend to 50 by virtue of 2014 rules of the company law, and it is for the purpose of, what is the purpose? Purpose is to share profits of what? Of a legal business. Profits of a business. We understood कि business क्या होता है? कोई भी every trade, profession or occupation Section 2B of the Indian Partnership Act defines the term business. So, relation or association between two persons but not more than 50 sharing profits of a business carried on by one or anyone, carried by all or any one of them on behalf of all. So, this is how a partnership is made. It may be made by a written agreement, a partnership deed, or it could be made by a oral agreement between persons. We have also seen how partnership is decided on the basis of both mixed laws and facts. It may be a question of law also, or it may be a question of fact as well. And we saw interesting cases of Cox versus Hickman. Benefits, no real relationship, all right. And we studied the cases of Pratibha Rani, Girdhar Bhai, etc. So, this is how we understand कि पार्टनरशिप होती क्या है. पार्टनरशिप फर्म और फर्म नेम और पार्टनर्स क्या होते हैं, अब हम वो देखेंगे. जब पार्टनरशिप क्रिएट हो जाती है तो उसमें जो पर्सन्स इंडिविजुअली इन्वॉल्व होते हैं, दे आर नोन एज पार्टनर्स. पर्सन्स हु हैव एंटर्ड इनटू अ पार्टनरशिप, वो सभी लोग जिन्होंने क्या किया है, एंटर हुए हैं पार्टनरशिप में. दे हैव एंटर्ड इन अ partnership. These persons individually यानी कि अपनी इंडिविजुअल कैपेसिटी में इन सभी पर्सन्स को क्या कहा जाएगा, इन सभी पर्सन्स को पार्टनर कहा जाएगा. All these persons who have entered into a partnership are individually known as partners. Section 4 ही कंटिन्यू चल रहा है. सेक्शन 4 ही डिफाइन करता है कि पार्टनरशिप क्या है. सेक्शन 4 ही डिफाइन करता है कि पार्टनर्स कौन है, और सेक्शन 4 ही ये बताता है कि फर्म क्या है और फर्म नेम क्या होता है. सो इंडिविजुअली दीज पर्सन्स हु एंटर इनटू अ पार्टनरशिप आर कॉल्ड पार्टनर्स, एंड कलेक्टिवली यानी कि एज अ ग्रुप, कलेक्टिवली जब आप इन लोगों को रेफर करेंगे देन दे विल बी कॉल्ड एज अ फर्म. Collectively, these partners are called a firm. So, let us say that A, B and C enter into a partnership. A, B, C enter into a partnership. These are all A, B and C individually called partners. Now, the firm of A, B and C, let's call it Messrs A, B, C. This firm will be known as firm. They will be collectively known as a firm. And this name Messrs A, B and C will be known as the firm name. Let us see what the section 4 talks about when we say firm name. These are partners in their individual capacity, but when collectively they are referred, they will be referred as firm, and the name in which they carry on their business is known as the firm name. जिस नाम से, जो नेम यूज करके वो अपनी फर्म का बिजनेस कंडक्ट कर रहे हैं, उस नेम को फर्म नेम कहा जाएगा. Name under which business is carried on is called firm name under section 4 of the Indian Partnership Act 1932. We will understand more concepts like what are the situations in which a person cannot be a partner. Section 6 explains how certain relationships are not partnership. Thank you for watching.